this is 202.16, the full version as promised. Matrimonial actions, calendar control of financial disclosure, in actions involving alimony maintenance, child support, equitable distribution, which is ED, motions for alimony, counsel fees, pendente lite, and child support special rules. Pendente lite just means during the action. So prior to judgment, somebody may request counsel fees so that they can actually prosecute the action or defend the action. A, applicability. This section shall be applicable to all contested actions and proceedings in the Supreme Court. I have a star there because it also could be in family court if it's referred, in which statements of net worth are required by the DRL to be filed, and in which a judicial determination may be made with respect to alimony, counsel fees, pendente lite, maintenance, custody and visitation, child support, ED, including referrals to family by Supreme. B, form of statements of net worth. Sworn statements, they must be sworn, except as provided in sub K, exchanged and filed with the court pursuant to the DRL, shall be in substantial compliance with the statement of net worth form contained in Appendix A of this part. So now we're going to look at Appendix A. And Appendix A, so you can see it has all the information that would be required. It says you have to have everything for the last 3 years. And it has to be accompanied by a retainer agreement with the lawyer and your most recent W-2, 1099, K-1, and income tax returns. C, retainer agreements. A signed copy of the attorney's retainer agreement with the client shall accompany the statement of net worth filed with the court, and the court shall examine the agreement to assure that it conforms to appellate division attorney conduct and disciplinary rules. Where substitution of counsel occurs after the filing with the court of the statement of net worth, a signed copy of the attorney's retainer agreement shall be filed with the court within 10 days of its execution. So the execution is when you actually sign the agreement with that lawyer while you're at the lawyer's office. That lawyer then has 10 days to file the substitution of counsel form. It's called a consent to change attorney here in Queens, and a copy of the attorney's retainer agreement has to be filed with the court within 10 days. 2, an attorney seeking to obtain interest in a property of their client to secure payment of the attorney's fee shall make application to the court for approval of said interest on notice to the client and his or her adversary. And that makes sense because in a matrimonial action, anytime someone is going to look to get an interest in any property, the other side may also have an interest in that property, the other spouse. The application may be granted only after the court reviews the finances of the parties and an application for attorney's fees. D, RJI. An RJI shall be filed with the court by the plaintiff no later than 45 days from the date of service of the summons upon the defendant, unless both parties file something called a notice of no necessity with the court, in which event the RJI may be filed no later than 120 days from the date of service of the summons upon the defendant. Notwithstanding Part 202.6a, the court shall accept an RJI that is not accompanied by other papers to be filed in the court. Certification. Every paper served on another party or filed or submitted to the court in a matrimonial action shall be signed as provided in Section 130-1.1 of the rules of the fucking chief administrator. And again, by now you should know that Part 130 is talking about an attorney signs a paper and certifies that it is not frivolous by his signature. F, preliminary conference. In all actions or proceedings to which this section of the rules is applicable, a preliminary conference shall be ordered by the court to be held within 45 days after the action has been assigned. That's a hard 45-day rule there. Such order shall set the time and date for the conference and shall specify the papers that shall be exchanged between the parties. These papers must be exchanged no later than 10 days prior to the PC unless the court directs otherwise. These papers shall include statements of net worth. Those also have to be filed with the court 10 days prior to the PC. 2, all paycheck stubs for the current calendar year and the last paycheck stub for the immediately preceding calendar year. All filed state and federal tax returns for the previous 3 years, including both personal returns and returns on behalf of any corporation where the party is a partner or shareholder. All W-2 and tax statements, 1099s, K-1 forms in the past 3 years, which the party did not file your federal income tax return. So if you didn't file a federal income tax return in the past 3 years, you have to actually submit your W-2 and tax statements, your 1099 and the K-1 forms, in lieu of your federal income tax return. Statements of all accounts received during the past 3 years from each financial institution, so a bank in which the party has maintained an account in which cash or securities are held. The statements immediately preceding and the following the date of the commencement of the matrimonial action pertaining to life insurance policy, deferred comp, individual retirement accounts, IRA, a pension, profit sharing plan, or KO or 401k, or any retirement plan. Both parties must be personally present in court at the time of the conference, and the judge must personally address the parties at some time during the conference. 2, the matters to be considered at the conference may include, among other things, and now there's a long list here, not going to read the entire thing, just read it, be able to recognize it, but you don't have to memorize this whole list. There's 6 things, and the last one, number 6, says any other matters the court shall deem appropriate. So basically, the first 5 are pendente lite relief, 2, compliance with disclosure, net worth statements, 3, simplification and limitation of the issues, 4, timetable for discovery, and that's 6 months. So know that matrimonials, 6 months for discovery, and 5, completion of a preliminary conference order substantially in the form contained in Appendix G to these rules with the attachments, and then 6, any other matters the court deems appropriate. At the close of the conference, the court shall direct the parties to stipulate in writing or on the record as to all resolved issues, which the court shall then so order as to all issues with respect to full custody and finance that remain unresolved. Anything not specifically described in writing or on the record at that time may not be raised in the action unless there's good cause shown. Court shall fix a schedule for discovery, and in a non-complex case shall schedule a trial date not later than 6 months from the date of the conference. Court may appoint an attorney for the infant children or direct the parties to file within 30 days of the preliminary conference a list of suitable attorneys for children so the court can pick one out. The court may also direct that a list of expert witnesses be filed with the court within 30 days, and the court can select a neutral expert to assist the court. So a neutral expert could be anything from like a psychologist to an appraisal expert to appraise property. The court shall schedule a compliance conference unless the court dispenses with it based upon a stipulation of compliance filed by the parties. Unless the court excuses their appearance, the parties, so the spouses, must be present in court at the time of the compliance conference. And if they're present, the judge shall personally address them at some time during the conference, which is interesting because it's not the court shall call the case on the record. It says the court shall personally address them at some time during the conference. G, expert witnesses. 1, responses to demand for expert information pursuant to 3101 shall be served within 20 days following service of such demands. The reason I did not harp on this time rule is because in civil, we know that if we're not sure, we guess 20 days. So this says, response to demands for expert information shall be served within 20 days following service of the demand. So I'm the wife, I serve a demand on the husband has 20 days to respond to that demand for expert information. 2, now here we go into the 60-30 time rule that's in the other video. Each expert witness whom a party expects to call at the trial shall file with the court a written report, which shall be exchanged and filed no later than 60 days before the date set for trial, and reply reports, if any, shall be exchanged and filed no later than 30 days before trial. Failure to file may, in court's discretion, preclude the use of the expert. Except for good cause shown, the reports exchanged between the parties shall be the only reports admissible at trial. Late retention of experts and consequent late submission of reports shall be permitted only upon a showing of good cause as authorized by CPLR 3101 D1i. And the reason that's important is because it used to not work like this. It used to be like, if you did not get your expert and disclose him in time, you were precluded. Precluded means you weren't allowed to use them. Now there's an exception that they wrote into the law that says if you can prove good cause and make this required showing of good cause, the court may allow you to introduce the expert. In the discretion of the court, written reports may be used to substitute for direct testimony at the trial, but the reports shall be submitted by the expert under oath, and the expert has to be present and available for cross-examination. So you still have to pay your expert to show up and be available for cross-examination. In the discretion of the court, in a proper case, the parties may be bound by the expert's report in their direct case. Interesting. H, statement of proposed disposition. Each party shall exchange a statement setting forth the following. 1, assets claimed to be marital property. 2, assets claimed to be separate property. 3, an allocation of debts or liabilities. 4, requested amount for maintenance. 5, proposal for equitable distribution. 6, proposal for a distributive award if requested. 7, proposed plan for child support and indicating the statutory factors on which it is based. 8, proposed plan for custody and visitation of any children and setting forth the reasons therefor. 2, a copy of any written agreement entered into by the parties relating to financial arrangements or custody or visitation shall be annexed to the statement referred to in paragraph 1. Statement referred to in paragraph 1 of this subdivision, which is the statement of proposed disposition. So the statement of proposed disposition with proof of service on the other party shall, with the note of issue, be filed with the court. The other party, if she or he has not already done so, shall file with the court a statement complying with paragraph 1 of the subdivision within 20 days of such service. Again, not going to harp on that time rule, just know it's there, but remember, guess 20 days if you're not sure. Filing of note of issue. No action shall be deemed ready for trial unless there's compliance with this section by the party who files the note of issue and certificate of readiness. J, referral to family court. When a case is pending in Supreme Court for a matrimonial action and the Supreme Court judge wants to send something to family court to be dealt with there, probably is about support, and they have to send all the documents that were exchanged and supplemental statements, and they have to be transmitted to the family court with something called the order of referral. K, motions for alimony, maintenance, counsel fees, pendente lite, and child support other than under section 237C, whatever the fuck that is. Okay, what does this say? This says unless there's an application is waived for good cause shown or services rendered by an attorney to secure the enforcement of a previously granted order or decree. The following requirements shall govern motions for alimony, maintenance, counsel fees, or child support, or any modification of an award thereof. 1, such motion shall be made before or at the PC if practicable. 2, no motion shall be heard unless the moving papers include a statement of net worth. 3, no motion for counsel fees shall be heard unless the moving papers also include the affidavit of the movant's attorney stating the monies, if any, received on behalf of the attorney's fee, the hourly amount charged by the attorney, the amounts paid or to be paid to counsel and the experts, costs, disbursements, or expenses, or any money attorney's been promised by. So basically they have to put all this information in their application for attorney's fees. Fees and expenses of experts shall include appraisal, accounting, actuarial, investigative, and other fees and expenses to enable a spouse to carry on or defend a matrimonial action pending in the Supreme Court. Do not think they're going to make a question out of this. Again, I'm doing this whole video, but I really think just know the 60-30 time rule, that 120-day rule, and the 6 months and the 45 days. 4, the party opposing any motion shall be deemed to have admitted for the purpose of the motion, but not otherwise, the facts setting forth in the moving party statement of net worth as are not controverted in a statement of net worth and sworn to by the opposing party and made part of the answering papers, or other sworn statements or affidavit with respect to any fact not feasible to controvert in the opposing party's statement of net worth. So basically, you have to put it, if you're saying you're objecting to something that the other side claims in their statement of net worth, then you're deemed to have admitted what they put in their statement of net worth, unless you file opposition with your own statement of net worth controverting it. And if there was no feasible way to controvert it in the statement of net worth, you have to have a sworn statement or affidavit with respect to those facts. 5, the failure to comply shall be good cause in discretion of presiding judge to either draw an inference favorable to the adverse party with respect to any disputed fact or issue affected by such failure. So if you don't do that, they can draw an inference in favor of the other party, or deny the motion without prejudice to renewal upon compliance with the provisions of this section. Okay, so if you make a motion for maintenance, but you don't put the proper stuff in your statement of net worth, the other side might get a benefit from that. Or the motion could be denied without prejudice until you refile and do it properly. So those are the two options the judge has. The judge cannot deny it with prejudice. They're only allowed to deny it without prejudice, or they can draw an inference favorable to the adverse party with respect to any disputed fact or issue affected by your failure to put the proper shit in your papers. 6, the notice of motion shall contain a notation indicating the nature of the motion. Pay attention. This is important. This is important. Again, this is 6. The notice of motion submitted with any motion for or related to interim maintenance or child support shall contain a notation indicating the nature of the motion. Any such motion shall be determined within 30 days after the motion is submitted for decision. This is different than a regular motion and a provisional remedy, okay? Because it's 30 days. A provisional remedy is normally 20 days the judge has to decide it, or 60 days the judge has to decide a regular motion. But if there is a motion for interim maintenance, that's during the pendency of the case, maintenance that you pay to the spouse, or child support, there must be a notation on the notice of motion indicating this is a motion for child support, or this is a motion for interim maintenance. And any such motion shall be determined within 30 days after the motion is submitted. So the judge gets half the time that they would get for a normal motion. They get half the time. They only get 30 days. 7, upon any application for an award of counsel fees or fees of experts made prior to conclusion of the trial, the court shall set forth in specific detail in writing or on the record the factors it considered and the reason for its decision. L, hearings or trial pertaining to temporary or permanent custody or visitation shall proceed day to day until conclusion. So that's a shall. So if it's got custody or visitation, whether it's temporary or permanent, it's supposed to go day to day. Whether or not it does, that's what it says here. With respect to other issues, to the extent feasible, the trial should go day to day. M, omission or redaction of CPI. So this is like a little different than what you're going to see in the regular rules. Okay, so this is different than the regular sealing because this is talking about when a judge wants to submit their decision for a publication. So it's not about filing papers with the county clerk, because a matrimonial action is exempt from omitting or redacting CPI when you're talking about filing papers with the clerk. This is about judge wants to submit something to the law journal or something. They're going to submit it as a publication, their decision or judgment. So prior to submitting that, the court shall redact these 6 things. 1, tax ID number, social security number. 2, home addresses of the parties and the kids. 3, the name of minors. You can use the initials, first name and last initial, or the word anonymous. 4, an individual's date of birth except the year. 5, the name of either party, when there's DV allegations. Again, you can say first name, last initial, both initials, or anonymous. And 6, bank accounts, numbers except the last 4 digits, health insurance number except the last 4 digits. So here's an example how you would write it. You could say, can't say when there's DV allegations, for example, you can't say Ray Rice. You could say Ray R, RR, or anonymous.